The next matter to come before the court this morning is Holly Trivett Fisher et al. Versus Kassim Ahmed et al. Both sides will have 15 minutes to argue. I know that the appellee has 15 minutes, though there are two appellees, so it doesn't matter to me how you divide your time. You, as the appellant, may reserve up to 5 minutes for rebuttal. As you can see, we have a clock up there. This is only my second time operating it. I hope you can rely on it. But if you let me know how much time you want to reserve for rebuttal when you get started, then I can keep prior to the passage of time and let you know. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, my name is Logan Trombley. I'm the attorney on behalf of the appellant, Holly Trivett Fisher. I would like to reserve 5 minutes for rebuttal time. To begin with, I'll just start with this brief statement of facts. On October 10, 2017, my client, Holly Fisher, inadvertently brushed, offended, or appellee in this case, Ahmed, in the hallway. In a crowded hallway, he was staying in the middle of it. In response, Ahmed tracked her down in her office, confronted her, berated her in front of her supervisor and coworkers, accused her of a physical assault. He was so loud that the supervisor told him to leave. He didn't stop there. He then walked into Judge Bro's court, interrupted an open court session, and loudly made the same accusations to the public and the court. He didn't stop there. The next day, instead of cooling down, he wrote a ranting letter, sent it to all of her supervisors and her coworkers throughout Summit County Courthouse. In that letter, he said that Trivett Fisher forcibly drove her shoulder into him, which causing a jarring shock, which almost knocked him to the ground. He even said afterwards that it almost caused him back pain. This is a serious accusation, and also he accused her of physical assault. It's a very serious accusation that triggered an internal investigation by the Summit County Courthouse. And in that investigation, they said, after review of all the facts and circumstances, the judges unanimously agreed that the allegations made by Kassim on October 11, 2017 are at minimum unfounded. The problem was that the outrageousness of his actions, everything he did, sparked a news sensation and a social media sensation because it was so outlandish. So not only was my client subjected to the emotional distress of fearing job loss, reputational damage, possible arrest, he filed a police report, but also she was subjected to public derision and public intrusion into her life.
Counsel, I understand the evidence, though, demonstrates that your client actually was the one that contacted the media.
So the evidence is that what truly happened was she was contacted by the media at first. They were going to run the story regardless, so she did a quote. And either or, it's immaterial. Once you publish any defamatory statement to a third party, where it goes is where it goes. It's distributed. It doesn't matter. The proximate cause is still caused by that. It was still proximately caused by his statements going off into ether. It would have been said.
I think we have case law that says if you disseminate something yourself, then it's not made public by the actions of the other party.
Well, it was made public. See, it was not disseminated by her. It was made public by the letter to everyone involved. If that triggered the investigation by the media, she did not reach out to the media herself. She was asked by the media for comment, and then so she gave comment just so she could have her side of the story. So that was more of the causal effect there. Moving on, for the procedural history, Fisher thereafter filed a complaint against Ahmed in Summit County. Both defendants filed 12B motions, motion to dismiss, motion for summary for judgment on the pleadings, and then the trial court asked for and adopted for a proposed opinion. Summit County provided a proposed opinion on behalf of both, and the trial court just adopted it completely without any alteration. So we're here today to appeal that adopted opinion, which we believe was just full of errors of law. So the first error of law issue. The primary issue is, did Ahmed's defamatory statements against Fisher arise from her employment relationship with Summit County? If that's the case, then political subdivision immunity is not applicable to the situation. The seminal case in this matter is Buck v. Reminderville, which is a 9th District case recently decided and affirmed by the Ohio Supreme Court. In that case, this court held that a defamation claim may arise out of the employment relationship, thus precluding political subdivision immunity. Specifically in Buck, it was a village chief of police who had a letter written against him by a subordinate in Reminderville that was distributed to the village council and the people there about his work performance, and he alleged that it injured his trade and occupation. So this court held that that was related to this employment. There's also some 8th District Court cases that are similar too. In Sampson, they've held that where an intentional tort is committed at the workplace, during work hours, in front of coworkers and supervisors, that is also related to employment. In Piazza, another 8th District Court case about a defamation claim, if the comments are about work performance, that is also related to employment. So the facts are similar in this case. The trial court, in its ruling, said the complaint pled no facts that proved that was related to this. It pled the following facts. Ahmed's letter was written on official Summit County letterhead and was distributed to Summit County employees and supervisors. This is just like Buck. The defamation was committed at the workplace during working hours in front of coworkers, just like in Sampson. And Ahmed's letter criticized Fisher's work performance, just like in Piazza and Buck. To quote his letter, he did say, "If Trivett is willing to act in a manner towards an officer of the court, I can only imagine what her interactions are with the people that visit the clinic." And he goes on to finish, "Her behavior must be addressed." And this is all to her supervisor. So it's obvious that his intent was to harm her employment relationship with Summit County, that everything devolved around her relationship with Summit County. But for her being a Summit County employee, the letter would have never been written, nor would the accusations probably been made in the first place. So, in conclusion, on this first time of error, Ahmed's defamatory statements arose from Fisher's employment with Summit County. For assignments errors 2 and 3, I'm going to lump them together. It's a simple issue. Did they plead malice? Did the complaint properly plead malice? It did. Notice pleading is the standard. This is according to David B. Matter. This is according to Mangalese for David B. Matter for employment immunity and Mangalese for qualified privilege. If you plead malice, it defeats both. What the complaint pled was Ahmed knowingly fabricated and recklessly overstated facts with the intent to get Fisher terminated from her employment, possibly arrested, and inflict emotional distress. Thus, Ahmed's statements and action were wanton, malicious, and bad faith. So not only does this plead it, it explains how he fabricated information, overstated information with the explicit purpose to harm the plaintiff. That is malice, that is bad faith, that is wanton and reckless behavior. That is pled. That satisfies the pleading standards in the situation. We're not required to prove our case at this point in the proceedings. Further, the trial court also somehow ruled that absolute privilege applies to this situation. It absolutely does not apply to this situation. Absolute privilege only applies when it comes to police reports and affidavits of prosecutors that could be used in criminal justice proceedings. There is no case law supporting the extension of absolute privilege into workplace violence reports, if that's what you can call this. There is no case law supporting this, and the public policy arguments against it are just innumerable. The final issue, the final one is about the First Amendment. Does the First Amendment protections apply to Ahmed's speech? First of all, First Amendment only applies where it's a public concern. There's no public concern here. It is an employee running, brushing into another employee in a hallway. It happens every single day. The public doesn't care. Just because you're a public employee doesn't mean your statements are entitled to constitutional protection. That's what the U.S. Supreme Court held in Connick v. Myers. So, the appellates might put the cart before the horse here and say, just because it became a public attention thing does not mean it's public concern. It only became public attention because it was so defamatory and so outrageous, and that's why it became so viral and sensational. And also, they argue that it's protected opinion. His statements are not protected opinion. Instead, he said that she forcibly drove into him with a jarring shot that almost knocked him to the ground and caused him back pain in the morning. This is a verifiable fantasy, a fantasy that was disproven by the sheriff's department, which did an investigation, and by the courthouse, which did investigation, which their findings are attached to the complaint. So it has completely pled everything that there's facts that are verifiable and are not opinions. And finally, he accused her of physical assault. That is a crime of moral turpitude. That is per se defamation. It's not an opinion whether or not somebody committed a crime. It's a fact. That is also not protected. So in conclusion, I pray this court does not affirm the dangerous precedent set by this trial court. I pray that it finds that Fisher's defamation claim arose out of her employment relation with Summit County, just like in Buck. I pray that they do not let absolute privilege extend to internal workplace violence reports. There's nothing supporting that. I also pray that they find that the notice pleading standard applies to the scienter of malice or qualified privilege and employee political immunity to that question, and that we have sufficiently pled that. And finally, I pray the court does not grant constitutional protection to Ahmed's statement because it's not a public concern nor a protected opinion. I thank you. We reserve the rest of my time.
Good morning, Your Honors. May it please the court, I'm Jacqueline Corrigan, and I represent the appellee Summit County. As the court has already acknowledged, there are two appellees in this case. To my right, Justin Greenfelder is representing appellee Kassim Ahmed, and we intend to divide our time equally. So I will be using 7.5 minutes, and Mr. Greenfelder will also be using 7.5 minutes. For the court's convenience, we have also divided up the issues that we will be chiefly addressing. Even though we're both prepared to answer whatever questions the court may have, it was my intention to focus the arguments on behalf of Summit County on political subdivision immunity, rebutting the appellant's arguments concerning Ohio's pleading standards, and also rebutting the appellant's arguments regarding the First Amendment's application to this case, while Mr. Greenfelder is more prepared to discuss the issues of privilege and the factual issues in this case. With that in mind, I will start by discussing the political subdivision immunity that both the county and Mr. Ahmed enjoy. Summit County and Mr. Ahmed are indeed immune under Chapter 2744 of the Revised Code from the Fisher suit as a matter of law. The real argument, as counsel has identified, really focuses on whether this matter arises out of Mrs. Fisher's relationship with Summit County, that employer-employee relationship. That's because 274409B exempts from political subdivision immunity cases that arise out of the employee's employment relationship with the political subdivision employer.
Before you get into that, let me just ask a question. If this truly were a libelous and defamatory message, it is or it isn't, but if it were, how would the county, if the county had adopted, for instance, the statements that the employee had made and so forth, how would the county be immune?
Because it's still a tort action, and because it still falls under, there are no exceptions that apply to that three-step process to determine whether the county has immunity. You know, we start from the standpoint of that we have immunity, then there are a specific number of exceptions that would strip immunity away, and then there's a third step which would restore immunity to the county.
I agree, but I guess what I'm getting at, and I'm probably not asking it correctly, if a defamation is proven, then that employee would not be operating within the course and scope of his employment, I assume. Because if he were operating within the course and scope of his employment, then there would be perhaps some liability to the county. So if they're not operating within the course and scope of their employment, because that action is not something that would be undertaken as an employee, then that employee would be subjected to civil liability. And the county may not be, but the Ohio Revised Code basically almost makes the county pay for it. Taxpayers' dollars, I guess, come into
that's correct, that the county would be responsible for indemnifying the employee.
Or could be responsible, at least duty to defend.
That's correct. I guess I'm unclear as to the rest of Your Honor's question.
Well, you started your whole presentation, I'm sorry, I probably got you all confused, but you started your whole presentation, your argument by saying it's clear that both the county and the employee, Ahmed, are immune under the Political Subdivision Liability Act. And I was trying to figure out why he would be immune if it was a defamation allegation.
Okay.
I'm sorry, I got you confused.
All right. Well, again, it is a tort action, and generally, 274403 does provide immunity for public employees. There are exceptions, only 2 of them, and only one of those exceptions is one that the Fishers have pleaded and argued, and that is that they've claimed that Mr. Ahmed acted with malicious purpose, bad faith, or wantonly and recklessly. And there are a few reasons why their amended complaint did not plead facts sufficient to support that conclusion. So, again, as a matter of law, he is immune. As far as counsel's arguments concerning whether the entire case arises out of Mrs. Fisher's employment relationship with the county, there really hasn't been any argument as to well, the assumption through this entire case is that everybody involved has been acting in the scope of their employment, okay? But that's not the test of whether an action arises out of the employment relationship, for Mrs. Fisher. Each of the cases that counsel has cited to Your Honors today have dealt with cases where the employer political subdivision has actually disseminated the defamatory statement or created the defamatory statement or engaged in the conduct itself. The mere fact that both of the employees involved here may have been acting in the scope and course of their employment really does not attach liability, does not make this as a case that arises out of the employment relationship. And I can give you an example why. For instance, if on my way walking here to oral argument this morning, if I had been crossing the street and a Summit County Sheriff's deputy in a cruiser had run me over in the street on his way to the courthouse to testify in another case, clearly both of us would have been acting in the scope and course of our employment. The accident had occurred while the deputy was on his way to court. That kind of tort action would not arise out of my employment relationship with the county, and neither does this case. So, with respect, this is not a case that falls into the exemption of 274409B. Now, as to the pleading standards that counsel mentioned, I'm not sure where my time is right now.
Well, you're going to give about 18 seconds if you're going to equally divide the 2, because it's 7:30.
My co-counsel is egging me on, I see. Regarding the pleading statements, I would let this court know that nobody has argued that the Fishers needed to meet a heightened pleading standard in this case. What everybody has done, however, is to hold the Fishers to the pleading standard that we already have in Ohio, and that's under Lawson Milk, Prizzuto from this court, Vargas from this court, which requires under Civil Rule 8 that a plaintiff plead facts, not conclusions, not statements of law, not opinions, not exaggerations, factual averments, in order to show that they have a cause of action that upon which relief may be granted. So, talismanic recitations of magic words like malice or anything else are not factual averments. They can be characterizations, but not facts. Also, it has to be remembered that any time a plaintiff attaches anything to their pleading, the courts are permitted to consider those attachments. And if the attachments contain information that contradicts or calls into question the averments of fact that the plaintiff has made, those averments of fact are stripped of the presumption that they are true when there's a 12B6 or a 12C motion, and the court cannot consider those averments in the light most favorable to the plaintiff. And that's what we have here. We have attachments, 104 pages of attachments, many of which directly contradicted the factual averments that were made by the plaintiff. And I will let Mr. Greenfelder expound upon those further. But in light of that, the trial court in this case did not have to consider those to be true. I will just very briefly say that the Mangeluzzi case that counsel refers to, that case did not depend on the recitation of magic words of malice. The plaintiff in that case had pleaded ample facts demonstrating the existence of actual malice to overcome the qualified privilege. And the same thing is true for the other cases that counsel has referenced in their reply brief. They don't actually apply. Now, just very briefly about the First Amendment. It is not the county's contention or Mr. Ahmed's contention that the First Amendment gives blanket carte blanche to say whatever one wants to say. The First Amendment applies to this case to do one basic thing that is critical to this case, and that is to require Mrs. Fisher to plead and to eventually show, if she had gotten past the 12B6 motion, that Mr. Ahmed's statement was false. Okay, this was a matter of public concern, as Mrs. Fisher avers in her amended complaint, saying that it was Mr. Ahmed's position that attracted news attention to what he had said. That is a matter of public concern. Now, as far as falsity, and I'm going to cut off my arguments after making this point, there is established case law from the United States Supreme Court, Mason versus New Yorker. There's also Tamburino from Ohio, which I cited in our brief. There's also Hover from the U.S. Supreme Court from 2014, also cited in the brief. Mere exaggeration is not enough to be falsity. Inaccurate or minorly inaccurate statements are not enough to be falsity. It is not enough for Mrs. Fisher to say, I didn't hit Mr. Ahmed that hard. What she was required to plead and prove, to plead falsity, was I didn't hit him at all. And the attachment she attached to her complaint showed that she did. And with that, I will cede the rest of my limited time to Mr. Greenfelder. Thank you.
Thank you. Good morning, Your Honors. May it please the Court. My name is Justin Greenfelder. I represent the defendant, appellee Kassim Ahmed, former Summit County Assistant Prosecutor. I'm going to do the warp speed version of this since I only have about 3 minutes here, and I apologize, but please interrupt and ask any questions that you may have. I intended to go through 3 points with you very quickly. One is employee immunity. Mr. Ahmed was an assistant prosecutor in Summit County at the time the incident occurred. He was standing outside a courtroom speaking with a defense attorney about a case. There's no dispute in this case that he was an employee performing a governmental function. Therefore, immunity is the rule, not the exception. And that's where the appellant has this backwards. He believes that all he needs to say is, Mr. Ahmed acted with malice, was reckless, or in bad faith, and he gets a free pass into discovery. That's not the case. He has to plead operative facts. The case law from all over the state of Ohio is replete with examples where simply saying malice, simply saying the words of the statute are not enough. In this case, he didn't do that. I would also like to remind the court that this was an amended complaint that was dismissed. This was his second bite at the apple. There were motions to dismiss filed after the initial complaint that pointed out each one of these pleading deficiencies. This was his second complaint, and he still could not plead sufficient facts to support a cause of action, to support overcoming the rule, which is immunity. Second point, very quickly, is on privilege. Now, whether you call it absolute privilege or qualified privilege, the result here is the same. There's no dispute here that the police report that Attorney Ahmed filled out is subject to absolute privilege. The appellant admits that in his brief, so at minimum, that portion of the trial court's order needs to be affirmed. I guess the dispute is over the workplace violence report. The standard under absolute privilege is, does it set a judicial proceeding in process? Does it set it in motion? And we would argue that under the facts here, it absolutely did. But even if absolute privilege doesn't apply, qualified privilege certainly does. It was presented to the right people. Attorney Ahmed followed the law. He followed Summit County Ordinance 169.19 that required him to make this report. What did he do after this? He went to his supervisor at the prosecutor's office. His supervisor told him, you need to report this. And he did. He followed the direction of Mrs. Fisher's supervisor in the psychodiagnostic clinic that said, if you have a problem with one of my employees, you need to send me a letter and tell me about it. He did. Mr. Ahmed followed the direction of his superiors, of Mrs. Fisher's superiors, and the ordinances of Summit County as an employee that he was bound to follow. Qualified privilege is built for specifically those types of situations. So we would assert that that applies. Finally, a couple of words on falsity. I would urge the court to take a look at the Grubb and Associates case that was decided by this court. Judge Schaefer, you authored that opinion. Judge Carr, you joined in it. It was a case in which it was a defamation case that was dismissed on the pleadings. It was affirmed by this court because the court looked at the documents that were attached to the complaint, determined that they contradicted the allegations in the complaint, and found that the complaint was properly dismissed by the trial court.
Thank you, counsel.
Thank you very much.
Counsel, you have 4 minutes for 7 seconds.
Thank you. So, just to address a couple issues. One, on this arising out of employment. They make this argument about the absolute qualified privilege, saying his employment relationship caused him to write that letter, right? Well, then it had to arise out of the employment relationship. But for the employment relationship, the letter would never have been written. But for the employment relationship, she would not have been at the clinic. He would not have done that and went and found her and said these things. Even in his letter, he says, I was shocked when I found out she was an employee. That created the situation. So I think the facts pled, right? And it cuts both ways. They could say, yes, the attachments count. I wrote an extensive complaint and amended the complaint just to even shore it up a little bit more. It was over 120 pages with 17 exhibits attached. It cuts and nothing contradicts anything written in it. The one thing they cite to that says contradicts is the sheriff report, where it says that Ms. Fisher admits that she bumped into him without malicious intent. Well, that's right. That's what we agree on. She bumped into him. Everyone agrees on that. But there's a big difference between somebody, and you can close your eyes and imagine this. If I say somebody inadvertently bumps into you in a hallway, or if I say somebody forcefully drove their shoulder into me, causing me to almost be knocked off the ground and have back pain the next day, what do you imagine in your head? Completely different things. We're not trying to and those are two separate things. One is what he's alleging, physical assault, violence in the workplace, a very serious accusation, especially in a courthouse. The other is alleging an innocuous thing that happens every single day and nobody cares about. There's a huge difference between them, and the ramifications that happen prove that there's a huge difference between them. Because if he was honest about what happened, and let's remember, he said what he said before the security camera footage came up there. He told the prosecutor's office what happened in his own words. They said, hey, you should file this report based off his words. And then the security camera comes out. And then the investigation happens. And then they look at it. And I just ask if that you want to look at the attachments, and if you want to look at whether or not I pled properly falsity in this case, look at Exhibit 8 to the amended complaint, which is the conclusion of this report, which says that he fabricated his claims that he was holding files in his hallway, that he fabricated his claims that she forcefully drove into him, delivering a shot, because he barely even moved in the video, and that was unprovoked physical assault. And all the judges in Summit County unanimously agreed that everything was unfounded. That is as big of a thing I could say, that this was untrue as possible.
How do you address her claim that mere exaggeration is not enough to be falsity, because she did in fact touch him?
She did, in fact, touch him, but the question comes down to two things. One, level of force, and two, intent. At no point does she ever say she intentionally did it. She was merely trying to get around him because he was in the middle of the hallway and somebody else was coming. She did not intend to hit him. She did not intend to bump into him. She did bump into him. Everyone agrees on that. But then, the question is the level of force. If she hit him like Vontez Perfect, in the middle of a football game, is what it sounds like, that's a big difference than somebody brushing up against someone in the hallway. It's a material difference. And just the reaction of the media to it once they found out about it shows why it was such a material difference and shows why it was so outrageous and defamatory what he said.
So are you saying it's not an it's more than an exaggeration, is that what you're saying?
It is far more than exaggeration. It is the completely opposite description of one event. It's very verifiable. It was verified via video evidence by multiple outside observers. And they found the factual allegations were unfounded, untrue. That's all that's required. Can it be proved true or false? Fisher's intent and the level of force are factual questions to be decided by a jury, not at this level of the pleadings. And finally, there are operative facts all over this proving malice, but it's summed up simply. He fabricated facts with the intent to harm her employment relationship. Harming somebody, right? Defaming somebody with the intent to harm them. Malicious is malice, bad faith, and wantonness. And we know he did this because he was in a rage afterwards. He followed her, and then he was in a further rage. He went to Judge Pro's court, and instead of cooling down, he wrote a letter.
I'm going to have to inform you that you all also out of time today. Thank you.
Thank you so much. I appreciate the time.
Thank you, everyone, for your presentations today. The court will take the matter under advisement, will issue a decision in due course, which will be mailed to all parties, as well as posted on the House and Court website. Thank you. We are adjourned.